It is January 15th, 2026, and this is the Court Gallery. Oh my. How's it going, y'all? Welcome to my living room and the Court Gallery discussion panel found here at Lone Wolf's Little Hangout. And we're doing it big time tonight, ladies and gentlemen. I just want to let everybody know, this is a Mama Wolfie production because we were going to do all McNally because I promise you, I think McNally lost a bet with somebody to take all his frustrating cases. But that's not to say that we're not going to watch those. We are going to watch a whole section of frustration with McNally at the very end of the stream. But first, we're going to check in with Judge SImpson. He's got a few people who really want out of jail, want to argue about it. Got a few people who might deserve to be in jail and aren't. We're going to see all that stuff. And then we're going to check in with Judge Ricky because, you know, it really doesn't matter what kind of case Judge Ricky is handling. It's always interesting. And he's got two very interesting cases. A city suing somebody for some things you'll hear about, and the other, the prisoner wants him to put in prison. It all starts right now.
Courthouse case, People versus John Brown.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Tate, with and on behalf of Mr. John Brown, who stands to my right. What's your name for the record, sir?
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. The court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor. We did go over that. Yes, we did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Could I have him sworn, please?
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay, I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking.
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so, all right, so you were in possession of a controlled substance that you shouldn't have been in possession of,
Yes,
correct?
sir.
All right, then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take.
that take plea to the higher the
All right,
charge.
sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
10 a.m. Washington.
February 12, 2026, 10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation. It's my understanding he's been in jail a week on that violation, and the basis of it was 2 missed tests, as well as I believe a test that was positive for THC. I have spoken about this to my client. He, of course, admits to the bond violation. He did appear last week in court knowing that he was likely to be remanded on the bond violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend and 4 children, ages 16, 14, 3, and 11 months in Taylor, Michigan. He further has full-time work doing cement and flooring. He's a finisher. He is asking if the court would consider reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands he cannot have a single more missed test. To my understanding, his positive test didn't have anything else positive besides the THC. He's willing to go untethered. My client even told me he'd be willing to do house arrest. I advised him that is likely not the appropriate sanction the court would issue. However, he understands he's not to do substances. He needs to.
I'm not going to change his bond. What he's going to need to do is he's going to need to talk to the probation department there, and then in Judge Washington's good wisdom, decide to change his bond.
Understood, Your Honor.
Your Honor, first I understand you say you're not going to change my bond. I just want to apologize
But
to the
you're
court.
still going to ask me? No,
Yeah, I just want to apologize to the court for my ignorance and not knowing that I was supposed to go over there. But I really need to get back to work. Like I'm down. I'm willing to go on tether, whatever. I just want to be able to get back to work. Right now, my girl's not working. I got 4 kids at home, very, very high rent.
Okay, sir, what I've indicated, and your counsel knows how to get through to 14B. They can contact 14B, get you interviewed, and then get to Judge Washington to set your bond. But at this point, I'm not changing your bond. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Caitlyn Quinn.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. For the record, Brian Stacy, P33014, on behalf of Miss Quinn. Morning, Judge.
Your name?
Caitlyn Quinn,
Oh.
Your Honor.
Judge, at this time, I have filed an appearance, substitution of attorneys, and an order for substitution, and a request for adjournment today because I was retained yesterday to get discovery from the defender's office.
All right. That objection. Probable cause conference will January 29th work for you, sir?
Yes, it does, Judge.
January 29th, 2026, 9 a.m. bond continued.
Well, Judge, wait, may I address that? Because she's still,
No.
the bond on the ROA says personal, and she's still in jail.
Hang on. Check.
I was confused why she would be there.
Yeah, Emily's looking right now.
I have it. I have it personal on the page. Yours shows what?
Right, yes. Which we have no objections to other than letting her go.
Is this her only case?
Yes, Judge, she has no priors.
Does she have a bond? But it doesn't say she's here on the bond, right?
While on bond, she's been testing. Her last test Thursday was negative. First test came back positive, and she said that's
Did have a violation
that she
from January 7th.
that she is that the one you appealed, the January 7th one? And I think that, and she appealed it, and I don't know if they got the appeal results.
Okay,
she planned
so
on
here's
testing.
what I have.
Okay.
And the reason why she's in, her bond must have been changed. Did I issue a warrant on this? Or is she being held on that? Being held pending. Have you seen the bond violation?
I know that she tested positive, Judge.
Oh, she did.
Yeah, that's what they say, and then she appealed that, and those results are not back. And she tested negative last week when she was arrested on Thursday, and that was negative.
When did she? So on December 30th, you're saying there's a test after that one?
She indicates to me when you were incarcerated on the 8th,
When I got into jail.
which she was taken into jail on the 8th. Were you out on bond before that?
Just recently, last Thursday, when I tested and got into jail.
Right, that's when you tested.
Yes, that's when I tested negative.
Is that the only time? Oh, that one was negative.
Yes.
Which one was negative?
She says when she went in on January 8th to the jail that one came back negative. But then there was one, why would there be one prior to that? Were you already on bond?
Yeah, she was already on bond. She
Okay.
was supposed to be testing, and just so council's aware, on December 23rd, she tested for numerous things. Well, she was positive for THC, which I don't think she has a card for.
She indicates she does have a card, Judge.
Okay, she didn't present it to them, but there were other things.
Not the card.
But I don't think she has a card for cocaine.
No, Judge.
Okay.
She is
Doesn't
on.
have a card for cocaine. And if that's not bad enough, that was on the 23rd. On the 30th, and I'm getting older, so I don't know. Do they have a fentanyl card? Because that's what showed up on that date.
That's why I can test it.
That's the one that she contested.
Yeah, that's the one she's contested. So
Yes.
not the cocaine?
No, Your Honor, but she indicates she didn't use after on bond. She used immediately before bond. And I believe that was 6 days later.
She She used the cocaine before she was placed on bond.
That's what she indicates to me, Judge.
Is it?
Yes, sir.
So when was December 17th, and it's showing up on the 23rd. Some good stuff.
What? Okay.
Yeah, that's right. I revoked her bond last time she was here
Okay.
because of those tests.
Very good.
I am not inclined to change it at this point. It's gonna sit where it is.
Well, Judge, if I
If
may,
somebody needs, well, it's gonna sit where it is until I get the results on the fentanyl. If she's contesting this, there's fentanyl in her system.
okay.
What about my last test from when I got?
Yeah, what about the jail test on the 8th?
What?
What about her negative jail test?
I don't know. I don't have a report on the jail test.
Oh,
And I don't know what kind of test that was. I mean,
the
I don't
urine
know.
test?
Yeah,
Urine. So I'm assuming it was a drug panel.
it was like.
Right, but I don't know if it went over through our system at community corrections. I don't have a report on it.
Right.
So I don't know if it was clean or whether it was or not.
But she would continue to test, Judge, and I believe she would continue to test negative.
She had 3 tests. And 2 of those tests, I mean, absent her prescription medications, 2 of those tests were dirty for something. I'm not changing my decision. I will take a look at it again if I get that other test
Okay.
or whatever. If I get the other test that you say she says she took, if it meets with the certain standards, or if, I'll look at it. Or if the results of the challenge to the fentanyl comes back, then I'll take a look at that certainly also.
We'll address that on the 29th then, Judge.
Yep.
Well,
Okay.
thank you for your time.
Thank you. Let's call the case of the people versus Terrence Ganyard.
People.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Mr. Ganyard.
For the record, Your Honor, my name is Terrence Ganyard.
And Your Honor,
He's waving.
he is waiving. I do have an offer to place on the record as it stands. That offer is that he waived for the purposes of pleading to 1 count of the firearms possession by a prohibited person. Count 2 and count 3 would be dismissed. It would also be a plea to count 4, the misdemeanor receiving and concealing 200 or more. That would come with a forfeiture of the weapon, restitution, if any, standard conditions upon that waiver. That's what people's understanding.
All right. Mr. Ganyard, you're waiving your right to a preliminary examination, sir?
Yes, sir, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do, Your Honor.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, we would acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all counts, court will enter a not guilty plea. Pretrial will be set for
January 27th at 1:30 before judge comes.
January 27, 2025, 1:30 before judge comes.
Your Honor,
Yes,
if we may address bond at this time.
briefly.
Your Honor, my clients, I think the court has the information from last time with regard to the blood results that he was able to take. At this time, I am still asking for his release. He's willing to do tether at whatever conditions that the court deems necessary to. He received a 7-day notice to quit, eviction notice that starts today. He has also got a kid who is autistic, whose birthday is today. He lost his job, unfortunately, as a result of this case, understandably so. He's going to need to move out of that location, as the court knows, for purposes of securing new housing for his family, his children especially. I would just ask for a plea for his release at this time on PR.
Any response from the people?
No, Your Honor.
Well, why are you drinking?
Sir,
Why are you? Go ahead.
so I got the blood test on the 2nd to show that I wasn't drinking. I wasn't drinking, Your Honor, on the 22nd. I didn't have any alcohol. That's why I went on my way to pay for a blood test. And the blood test, the levels was 1.0 and it said 1.4 is 0 to low alcohol.
Yeah, but
Yes, sir.
I remember going through all of that last time, and I'm telling you that test doesn't tell me much.
We understand that, Your Honor.
Because I've got repeated tests where on the 22nd and the 27th, you're testing positive, you're drinking.
The one time I did say that I was drinking in November, Your Honor, I did admit to that. I definitely did. And you said we'll put it for
Put it over.
we'll adjourn it or whatever. And then we just got to this adjournment with what I proved that I wasn't drinking. And
No, you didn't,
sir.
Oh, hold on.
Okay.
You didn't. That's not what that test shows me.
I have, so CMH has given me what I wanted to tell you, a shot.
The Vivitrol?
Yes, and that's like an alcohol blocker. And they said if I drink on that, bad things can happen to me.
Where is that information?
That's with CMH, sir.
Your Honor, I don't have receipt.
I don't have that before me. You're telling me
That's what I'm going to be put on. I'm already taking.
so you're not put on it right now.
No, sir.
Your Honor, I would ask for consideration for random drops at this point, if the court would be willing to consider that. I think that would, I think testing in front of someone at this point may be helpful in terms of monitoring the situation versus the scram tether or sober link. I would ask for consideration for that. I do know that my client has a desperate need to leave the jail.
I understand that, but I also understand what he's done to get himself there, because he wasn't there to start with. And now you're asking me to change it, and I haven't been shown anything really that's convinced this court that those episodes didn't occur. And he's not on a medication that's going to stop him from drinking.
For your mama. Hey, dude, I'm on.
Seriously. So this is, I mean, nothing's changed from the last time that I denied it. And so he'll be up before Judge Conkey. Maybe she'll feel differently than that. But
I'll do anything to any type of drops, though, Your Honor. They do want to put me on the thing today as far as the Vivitrol. They told me tonight I can get a shot, but it's also if I'm going to be here.
You're telling me that, but I don't have anything that indicates that. I have nothing in writing saying that's what's going to happen.
I just was trying to move, man. I know I have to move, but I have a 7-day eviction. Since I've been in here, I don't really know what to do. I have an autistic son. I have a lot at home.
Ganyard, I understand and I can appreciate the circumstances. That
No scram tether or anything I can do, sir, for you? Anything, just for a week, just to show till I come back to court?
I'm not changing my position on it. I've said what I've said. You can take it before Judge Conkey. She may feel differently. All right. Bond is denied. Thank you. Court calls the case, People versus Tegan Donnell. Donald. This is one I have to address.
Let's get the postman on behalf. Ms. Donnell? Ms. Donnell, could you please tell the court your name, ma'am?
Tegan, Summer Strader, Donnell.
What are we doing?
I'm going to be requesting an adjournment. I believe I did provide a green sheet to the court.
Yes, you did. You want to address the bond violation?
Yes, Your Honor, with regard to the bond violation, I believe Ms. Donnell would be prepared to admit to it, and she has checked herself into treatment.
I do struggle with addiction, and I am currently have checked myself into Spera Recovery Center.
To where?
Spera Recovery Center, it's detox. Excuse me, I don't mean to interrupt you. I did a level of care assessment. They recommended a 30-day program, and then I hopefully will go to
Are you
transitional
in
housing.
the, I don't have any of that.
Your Honor, I did provide that to the court.
And I have spoken to my bond advisor as well.
Where's the Dawn from? Is she in currently?
Yes, Your Honor.
Was she in at the time of these?
I believe she checked herself in after the violation. Is that correct, Ms. Donnell?
I found out about my violation actually.
Oh, which violation?
I'm sorry, what? Yes, I've been struggling a lot, if I may speak.
I have 1, 2, 3, 4, 5, 6, 7
May I adjust?
tests for cocaine.
And Ms. Donnell, my understanding is that you.
And are you on a prescription that's an amphetamine?
No.
And so 3 tests with the cocaine that also tested positive for amphetamines. Then on January 13th, she missed.
Yes, Your Honor. And she will freely admit that to the court, that this is a result of her struggle with addiction and that she has now checked herself into spare for detox.
No, that's not going to be good enough. You didn't do that until when?
I've been there since Saturday.
Yeah, that's the problem. These tests, and you say it's because you were struggling with these, and that you also got a notification of a positive test. Your positive test date back to November 26th.
There was, may I speak?
Yeah.
The first test I had was positive and it was a false positive. So I sent that out and it came back negative. Then after that.
What test is that?
The very first one.
On what date?
November 26th, probably. After that, I have struggled with addiction. I went to Oakdale for 3 days. I got out and I've been homeless and I didn't have a place that was substance free and I continued to struggle. I take responsibility for my substance use and I continued to struggle and if I have to go to jail, like I understand that. But I didn't know I had a bond violation like warrant out for me until after I went to Sparrow.
Till after you went?
Yes. But I assumed it would happen eventually anyways. I'm just surprised it didn't happen sooner. I struggle with addiction.
I get that, man.
I know.
And I don't know why you're not an inpatient when I'm looking at this.
I am an inpatient.
For 30 days.
Correct. I'm here with an RSS, a recovery support specialist with me.
Maybe I should have put it this way. Why weren't you in there earlier?
There's no excuse. I went to Oakdale for 3 days for a little like detox thing and I got out and I was like, oh, I got a job. I'll be able to do that. And I was still struggling so much I didn't follow through with the job. So as soon as I realized I wasn't going to be able to do the job, I got myself into inpatient. I shouldn't have expected myself to be able to work a job when I was getting high.
Where are the amphetamines coming from?
I don't know. That may be a medication I'm taking or something. Or something in this. No, I don't like, it's difficult to be up here talking about, hey, I struggle with this, in the first place. But
And you're saying the reason that you missed your recent test is because you're an inpatient?
correct.
It's a 30-day, and so when are you expected to be done with this?
I checked in on the 10th, so roughly about the 9th or 10th of February.
Well, during this to February 12th, 2020, 6 at 9 a.m. That's for PCC and sentencing on the violation. I will let you continue in treatment, but you are to get over to community corrections for placement on a tether, location tracking tether.
Thank you, Your Honor.
Her bond will continue otherwise.
Thank you. Should she go over there now?
She better.
Okay. You know.
Court does call the case People versus Chilisa Floyd.
And that can be approaching.
Why is Cannon hugging people in the aisle?
Your name.
Your name, ma'am.
Oh, Chilisa Floyd.
Thank you.
Your Honor, requesting to adjourn this matter. We're still waiting for some discovery.
How soon do you have it? I mean, if we're waiting discovery.
So I believe it's supposed to, we requested it the other day and I was supposed to be receiving a link, a WatchGuard link for the discovery, but I never received that link. So
We can give it to them as early as next week.
So
Can we? Oh,
What did you want to say? You wanted to say something?
yes, sir. I was just.
I'll talk to you. I like talking to you more than I like talking to them. So go ahead. What do you want to tell me, ma'am?
I was just gonna say 2 weeks because I'm starting a new job at Chrysler, so I don't know what my schedule
Your
is gonna be.
schedule's gonna be?
Yes, sir.
All right. So when do you start that?
Next Thursday.
So you start that on the 22nd?
Yes.
All right. And then you're gonna have to get to your attorney. Everybody's gonna have to look at it. While we're doing all that, you don't want to lose your job.
No, sir, I don't. Thank you.
And here's what I'm gonna do. I'll put the probable cause conference out to February 12th, 2026, 9 a.m. And she's working and doing that. If she can find a way to get it done, then she submit the forms, let her appear via Zoom. And we'll try to time it up so she won't lose her job. You're welcome.
Thank you.
See, if they had said it, it would have all turned in and I would have just denied everything. But the way you asked. All right.
Address bond, sir.
Pardon?
Can we address bond also, sir?
Your bond?
Yes, sir.
Oh, you're
If
telling
she
her what to say now?
If she asks, you won't deny it.
All right. What about her bond?
My bond condition.
Your Honor, she has right now, there's a no-go to her current house where she lives, so she's not able to go there. So we are asking if we could change that to allow her to go back home. Right now, she's been living at friends' homes and she's still paying rent and mortgage on that home that she can't go to.
Your Honor, the people that oppose the modification to the bond, they'll go to, especially as the complaining witness is currently residing at that location. He is in the process of moving out. He's asked us to get at least 2 weeks for him to be able to do so. But at this time, he would like the no.
Your Honor, it's her home and he has no right to be staying in that home at this time
So how do you get in there?
because there's no go.
No.
Originally he was staying with her as, but
Yeah.
not as a resident there. It was just a one-time thing.
We were dating.
What?
We were dating. I'm in love with him. I am in love with him.
Okay. That's fine. I get that. And I guess that was going to be my point. I understand it may be her home, but I don't really think if this court's going to be consistent, I'm not going to change that where that person is still in the premises.
So in 2 weeks, he indicated that he's moving out within 1 to 2 weeks. Should we?
Well, here's the problem. Even if she doesn't, or he doesn't move, then she's just caught at that point. I'm not going to change it to allow him to go, or allow her to go back until he's just vacated the premises.
Your Honor, when we receive confirmation that he has left the premises, I'll reach out to defense counsel. He can submit a stip to allow her to return to the address.
Well, I've given him an eviction notice already.
Okay, that's gonna be a whole other problem. Because whenever people are in the middle of a domestic,
I didn't give.
Where's the property?
It is A359 Brookstone, Willis, Michigan.
I don't know if that comes here or not. It's in Washtenaw County.
Yes. Yes, sir.
Right next to Ypsilanti.
Is that 14B? Is it 18? Well, there's only, well, if it comes before me, I'm gonna throw it out because I don't allow eviction cases on domestic cases either, for very good reason. So he needs to just move. And then there'll be the stipulation and you can go back.
Thank you, Your Honor.
Okay, bond will continue.
Thank you.
Court calls the cases of the People versus Terry Prote.
Good afternoon, Your Honor. Raymond Cook for the People.
Oh, yes.
And Assistant Public Defender Natalie Pate with on behalf of Mr. Prote. To my right, please state your name for the record, sir.
Terry Prote.
Thank you, Your Honor. Your Honor should be receive a green sheet. I'm respectfully requesting an adjournment. I was just able to make contact with
Counsel Prote, do you have the bond violation?
I do, Your Honor, and I'm also prepared to address.
Okay, you ready to address it? Okay, go ahead.
So, Your Honor, as I was going to say, I just made contact with Mr. Probst this morning. He provided me with a new phone number. I was able to review the bond violation with him. When he was reviewing it with me, he told me that he went to community corrections on December 29th. I did then email Ms. Dozier at community corrections, and she stated to me that this morning that she just had the front desk check in the sign-in sheet, and it appears that he did sign in that day. If
the 29th?
Yes. However, it was not his day and he would have been turned away unless we received an order from the court. Obviously, since then, Mr. Probst has had a lot of missed tests and did not go back to report. I asked him why, and he said that when he went on the 29th and they told him he wasn't on the list, he was confused, did not come back. I advised him that that was the wrong thing to do and he should have continued contact with them and gone back to community corrections. He did also, Mr. Probst, that is, provided me with a document from Home of New Vision that he says is from 2 days ago that does, I just received this morning, Your Honor, so I apologize. I was unable to provide it to the court or the people in advance, but it states that he's working with a Marcus Pollard at Home of New Vision, working to help get him through access. They are waiting on a follow-up communication so he can proceed with the next steps in his recovery, hopefully to get into rehab. That being said, Your Honor, I do have the documentation as from the Home of New Vision from 2 days ago that Mr. Probst provided to me. He is willing to engage in community corrections testing. And I believe he is confused.
He's missed 15 tests.
That is true, Your Honor. Yes.
And the 2 that he took, which were actually in September, he tested positive for cocaine.
That is correct, Your Honor. And then he was in jail and released on December 23rd. And obviously, I acknowledge he has not tested since he's been released from the jail on December 23rd. But positively speaking, he has been working with Home of New Vision. He did go on the 29th. Again, he should have continued to go back. And I did advise him that that's what he's supposed to do. I would ask if the court would consider ordering him to go to community corrections today and possibly come back based on the test results.
I'll adjourn this to the 29th, 2026, 9 a.m. But at this point in time, the defendant needed to do something else. He has attorneys, he has all kinds of tools at his disposal. He has in his bonds revoked Defendants remanded.
Yourself?
Case entitled City of Rose Hill, Kansas versus Rodney James Godfrey, case number 2025 CR 531. Justin Phelps appears on behalf of the City of Rose Hill. Randy Price is counsel of record for Rodney James Godfrey, who appears separately from his lawyer by Zoom. This matter comes before the court at this time for initial appearance in district court, following this defendant's attempt to file a notice of appeal and moving this case to district court from municipal court following trial in that court. The first issue that I want to address here is Mr. Price's involvement. By case law, he's required to appear at the first appearance in district court because he was the counsel of record in municipal court. Mr. Godfrey, do you still want Mr. Price as your attorney at the district court level?
Considering I'm unable to afford an attorney at this time, I don't know how that would work, considering part of my appeal involves him. If so, yes.
Okay. The last thing you said, part of your what involves him?
The appeal.
Okay. All right. Mr. Godfrey, a couple of points I want to make here. Don't send the court any more stuff. I got a large envelope from you with a apparent attempt to try to influence the court in some way with your written materials. This is not an appellate court in the traditional sense. This court is not going to review what happened in Rose Hill Municipal Court. And you're under the impression, apparently, that this court will do that. What happened down there happened down there. You're in district court. You're entitled to a trial de novo, which means you get to start over. The judgment of the municipal court at this point is stayed pending further proceedings in district court. But don't send any more materials to the judge. Number one, it's ethically improper. Justin Phelps can't send stuff behind your back to me if it deals with the substance of the case, and you're not allowed to do that either. Not to mention the fact that you did have an attorney of record, Mr. Price, at the municipal court level. So the court's going to not consider any of the materials that you sent me. Some of it has some improper material in it anyway. So in the future, if there's any legitimate motion to be filed, and your attorney's going to know this, file it with the clerk of the district court. You don't send it directly to the judge. All right. If you're satisfied with having Randy Price as your lawyer, we'll continue in that fashion, Mr. Godfrey. But you state that part of the appeal involves him. So does that mean you're disgruntled and dissatisfied with his services as your lawyer?
Yes, Your Honor. I would like to also just add real quickly, if possible, that I was unaware sending that to you was considered as such. Was not my intent. I was under the pretense that I was supposed to send to the court, to the appellate court, as to what I was sending to the city council as well.
The city council?
I meant the city of Rose Hill, being Justin Phelps.
All right. Mr. Phelps, did you get this latest packet of materials from him?
The only thing that I have seen is the 19-page, what he calls his appeal that was received back on December 4th. That's all I've seen.
All right.
If it went to the city, then I think I was last out there on Thursday. I haven't seen anything in that regard.
Okay. Well, the heading on the cover page only included this court as a recipient of this packet. But again, the court's going to disregard and not consider these materials. All right. So getting back to our threshold issue, Mr. Godfrey, we need to go forward from here. You have the right to be represented. If you can't afford a lawyer, one can be appointed for you, even at this level. Apparently, the municipal court did appoint Mr. Price as an appointed attorney. Are you not working currently, Mr. Godfrey?
I am. I'm still getting back on my feet. I just got back to work prior to my mother passing, and then she passed, and that created an issue financially. So I am working.
Okay. How much money do you make at your job?
I make $28 an hour.
Okay. On its face, it would appear that you would have the resources to be able to hire a lawyer on a misdemeanor case at the district court level. You say you're getting back on your feet.
Yes, sir.
Not real sure what that means. I'll note that the municipal court apparently certified you as qualifying for a court-appointed attorney. But we'll get back to the issue of whether Mr. Price is going to be asked to continue as your lawyer at this level or not. If there needs to be a change, we need to make it now, Mr. Godfrey.
Okay. I'm asking you because I do not know. Part of my appeal is based on I feel there's unsatisfactory representation by Mr. Price for me in several regards. One being I'd asked on 2 occasions via email to have been either sent email or by letter the actual evidence so I could review it myself. That was never replied to. It was ignored. And I had asked him the day before, it was on a Tuesday before the last court session, as if we were going to have any discussion about the court case, what was going to happen. He did not reply then. And right at the start of the case, when the camera came on before it started, he just told me, look, we're going to plead no contest, and then the judge is going to find you guilty and go on. And at that point in time, what am I supposed to do? So I agreed to that. And for me, I feel that's a huge dereliction of his duty.
All right. Mr. Price, I appreciate your appearance here this morning. Okay, you may be muted or your speaker volume's down, so I'm not hearing you. All right, you heard Mr. Godfrey's comments. I know you're in a difficult situation regarding response. Do you feel like you can continue to represent him in this case?
No, for a couple of reasons, Your Honor. First of all, you said that this was a trial. It was actually a plea. Okay. Number one, he's filed this appeal pro se without my knowledge. And then, again, I'm the city public defender for the city of Rose Hill. I'm not engaged to handle appeals. I've asked the city about that, have not received a response. Finally, Your Honor, he alleges that I'm ineffective in his documents here, and he's told you the same thing. So I don't think I should be permitted to continue in the representation.
Very well. The court will find that there is some dissatisfaction here, which the court believes justifies relieving Mr. Price for the reasons stated here on the record. Mr. Price, I do appreciate your appearance here this morning. I'm going to relieve you from further responsibility at the district court level.
Yes, sir. Thank you, Your Honor.
All right. You're free to leave the meeting or stay with it based on your election.
I'm headed to a preliminary hearing in a homicide. Thank you.
All right. Very well. Thank you, Mr. Price.
Sure.
All right. Mr. Godfrey, I think you need an attorney at this level. You claim you can't afford one. I'll ask Mr. Phelps, the city attorney, is there a backup public defender or a second public defender at the city level that this court can assign to the case?
I don't know the answer to that offhand. I am certain that we've run into conflicts before, and we can certainly look for one to be appointed. If the court would humor me, I'm not. I can understand the court's concern in making sure Mr. Godfrey is represented, but before we conclude that discussion, I would like to be heard on whether the appeal was timely docketed and whether it's appropriate for that determination to be made here in district court, or if his request for relief is more appropriately in the municipal court.
This court will make its own decision regarding its jurisdiction.
Okay, fair enough, Your Honor. But I would say, as far as the appointment of an attorney, if an application can be submitted to the city clerk will attempt to locate someone that will represent him.
All right. What type of application do you use?
I'm usually not involved in that process. I know that we have forms at the city. Let me see if we've got one online, Judge. I don't know that we do, but let me see. Actually, you know what? I'll email the clerk right now and just ask her if she can send me one. Okay. I don't know how quickly they'll be able to get back to me, but I can get a copy of one of those forms. And if it's appropriate for me to send that to your administrative aide or directly to Mr. Godfrey, however you would prefer that, Your Honor.
At this point, he's not represented by counsel. I think that you'd be authorized to send it directly to him.
Okay. Mr. Godfrey, do you have a email address that I can use to send you that application?
I do. Whenever you're ready, let me know.
Go ahead.
The letter J.
Can forward that to Mr. Godfrey.
Thank you, Mr. Phelps. Now, turning to this issue regarding the filing of this case, Mr. Godfrey, let's state here for the record, how did you file your case with the clerk of the district court?
I filed it at the same time I'd sent the district court. I filed at the same time I did with the municipal court. It was, by the time I got everything complete, it was, I think, the day after Thanksgiving.
Okay, I didn't really say when. I was asking how you filed. Was it by regular mail, certified mail?
Certified mail, sir.
Okay.
As were the initial packets that y'all last received.
Do you have your certified mail return receipt?
Yes, sir. I'd have to. Not with me at the moment, but also have screenshots of where they were sent to via my email and received and signed.
Okay, so you have a screenshot of the return receipt?
Yes, sir.
Okay. Can you call that up?
No. Well, let me see that I did. I have a USPS tracking. I just took another screenshot of it. I don't know how I would call it up onto my phone for y'all to see. But I have one. I can submit it to you if need be. Where did it go? Forgive me. You will wish to write down the tracking number. That's the best I can do at the moment.
If you have a tracking number, that would be helpful.
Whenever you're ready.
Yes, go ahead.
It's 958.
Okay, that's a long number, Mr. Godfrey. So I'm gonna read this back. Okay.
All right.
I wrote down 958.
That's correct.
Now that would be the tracking number on the certified mail receipt to Butler County District Court, correct?
I believe so.
Okay.
Looking for. I sent one to Rose Hill and one to Butler County.
Okay. Then I'll also need the one that you sent to Rose Hill.
Okay, one moment.
It's okay. Take your time.
Being honest, I'm not sure which is which.
Okay.
But
that's fine.
Yeah. Okay. The other one, whenever you're ready.
Go ahead, sir.
958.
All right. Okay. I may have lost part of the sequence on that second one, so I'm going to read it back. 958, correct?
Correct. That's what I've got. And I pulled those up on USPS's website if you want me to share screen.
Okay.
Judge, you able to see that?
I am.
Okay, this is the number that he gave, the first number that he gave. Appears to show is delivered in El Dorado on December 3rd.
If I may, those might have been the packages that you received that you did not want to accept. Will you give me 1 second while I go see if I find the other receipts, please?
Sure.
Thank you.
The other packet was January 5. It's the date that's on the outside of the envelope. So I think we're talking about the initial filings here.
Yes, sir. That's what I'm confused on.
Okay, December 3rd. And then Mr. Phelps, the one to City Rose Hill?
This one right here. Is that showing up?
Yes, it would appear December 4th.
Yeah, December 5th.
All right. Mr. Phelps, I know you have some jurisdictional arguments to make. However, I don't want Mr. Godfrey compromised by the fact that I've relieved his attorney. I believe any determination regarding this court's jurisdiction, he should have the benefit of counsel. So I don't want any delays in appointment. Quite frankly, the municipal court at this point is out of it. The district court sits as municipal court. I think that this court will determine an appropriate attorney to appoint based on our available list of attorneys that handle cases such as this. And the court will make such an appointment. And obviously you'll be advised, as will Mr. Godfrey, as to the attorney that's been appointed by the court. And then we're going to establish another court date now to bring this matter back before the court. At that time, Mr. Phelps, you'll be able to make your jurisdictional arguments. We will reserve setting any type of further court dates until this jurisdictional issue has been resolved one way or the other. So I'm currently looking at the possibilities of doing this either Tuesday, February 17 or Wednesday, February 18. Your availability on those dates, Mr. Phelps?
Let me check my calendar, Judge, and I apologize if I'm a little distracted at the moment. I did get that form and I am emailing that to Mr. Godfrey.
Okay, go ahead and do that, counsel.
Okay, that is done now. You said February
17 or 18.
The 17th I have available.
All right. I've got quite a bit in the morning. Would you be available at 1:15 p.m. on that date?
I would.
Okay. All right, Mr. Godfrey, I kind of lost your picture there.
Okay, hold on 1 second. Let's see what's going on here. Trying to get to my calendar to put that on.
And I'll ask my assistant, can we use the same Zoom numbers as we did today, Mandy?
Yes, Judge.
Okay, so you've already got the Zoom link, Mr. Godfrey. I'll need you on the meeting at 1:15 p.m. Tuesday, February 17.
Okay.
And at that time, the court will hear arguments regarding the jurisdictional issue before the court. In other words, was your case timely filed? And does this court have jurisdiction as a result? And then if the court determines that the case goes forward in district court, further scheduling and other orders will be made at that time.
Yes, sir.
In the meantime, then, Mr. Godfrey, your municipal court conviction and action on that conviction is stayed, so you don't have to worry about that. We'll take it up 1:15 Tuesday, February 17 by Zoom. And then I'll expect you to have communicated with your court-appointed lawyer prior to that date.
Yes, Your Honor.
Okay. And we'll try to get that appointment order out as soon as we can. All right. With all of that stated then, Mr. Phelps, is there anything from the city's perspective that the court needs to address at this time?
And if I missed it, I apologize. I just want to be clear, when he has completed that application, I would recommend he submit that directly to the clerk of the municipal court.
Well,
or do you want it to come to you?
I want it to come to my assistant.
Okay.
So thank you for that question, Mr. Phelps. I think that my assistant will be directly involved in the appointment process and preparation of that order. I would just soon receive that information directly.
Okay.
Okay. Unless the city has a pre-arrangement regarding conflicts at the municipal court level, I'll follow whatever their procedure is, but if they don't, and I seriously doubt that they do, then we'll make an appointment here in district court.
That's fine, Your Honor. That's
Okay.
fine with me.
If you'll just get that to Mandy. All right. All right. Any questions?
I want to make sure Mr. Godfrey knows how to get that to Mandy.
You have my assistant's email address, Mr. Godfrey? I think you do. 'Cause I think she's already emailed you before, I think.
Let me check.
Judge, I am sending it to him right now.
Okay.
Okay. All right, I got that from you, Mr. Phelps. Thank you.
Okay. Godfrey, do you have my assistant's email address?
Let me double check one.
It should be in the chat. I just sent it to you.
Yeah, I just saw it. I went to go check out. Yes, sir, I do. Mandy, do that.
Okay.
All right. Any other questions for the court at this time, Mr. Godfrey?
No, Your Honor.
All right. Then at this time, this Rose Hill matter will currently be in recess. This meeting may be ended for all at this time.
Thank you, Your Honor.
State of Kansas versus Charlie Albert Mitchell. Case number 2024 CR 511. Charlie Mitchell appears from the Butler County Detention Facility Zoom location. James Watts is defense counsel. Brett Sweeney on behalf of the state. This matter comes before the court at this time for sentencing. Court knows that the defendant appeared before this court on September the 12th of 2025, pled guilty to count 1, possession of methamphetamine, a level 5 drug felony. Pre-sentence report was ordered. Sentencing originally set for November the 3rd. The defendant failed to appear. The court issued an order of bond forfeiture bench warrant, no bond hold. A pre-sentence report has been completed, however. We are ready to proceed to sentencing today. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history?
No objection, Your Honor.
Any objection by the defense, Mr. Watts?
No, Your Honor.
All right. Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Mitchell case this morning?
I know of none, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, Your Honor.
Charlie Mitchell, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with sentencing today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No such motions, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of a victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, pursuant to plea agreement, the state would recommend a mitigated 14 months in Department of Corrections, the corresponding good time percentages of 20% and post-release supervision duration of 12 months. If my math is correct, I believe he has 105 days of jail time credit. As the court previously noted, he is presumptive probation, and pursuant to his pre-sentencing scores, he also falls as a mandatory Senate bill individual. And so the state is recommending up to 18 months of community corrections probation. Would ask that all the standard conditions that are listed be adopted as they all appear to be appropriate, as well as obviously the Senate Bill 123 treatments and any aftercare recommendations. It looks like the initial modality that's being recommended is intensive outpatient. As far as costs and fees associated with this case, Your Honor, the state's not requesting a fine. We are, of course, asking for the court costs. There was a $400 KBI laboratory report fee, $300 payable towards the Senate Bill 123 treatment, community corrections and supervision fees, and then, of course, if appropriate, attorneys and bids fees.
Okay, thank you. Mr. Watts, your recommendations regarding an appropriate sentence.
Thank you, Your Honor. Your Honor, recommendations will largely track the state's recommendations. Likewise with the state, 15 months in the Department of Corrections with the standard 20% and good time, and the post release as well. As Mr. Sweeney noted, this is Senate Bill 123 case. So this would be placed in community corrections with the normal and usual conditions of Senate Bill 123. Most importantly, to obtain a drug and alcohol evaluation, although that part is largely already done as a result of the PSI, and do treatment consistent with that evaluation and complete it successfully, as well as the other normal standard conditions of probation. I don't think I have anything else, Your Honor.
Are your fees in the representation of the client?
Thank you, Your Honor. It's billed at $1,100 to bids.
Thank you. At this time, the court will address the defendant, Charlie Mitchell, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that you would like to present to the court. Mr. Mitchell?
Your Honor, I'd like to go to prison. I know I won't be able to do Senate Bill 123. I'll fail it within like the first week of being out.
Why do you think that's the case, Mr. Mitchell?
Because I have no place to stay now. My homie's not gonna let me stay with him. And everywhere else I have to stay, there's drugs. And I know I'll be right there smoking alongside everybody else. So I'd like to just go to prison, get my time over with, and get back home to my family.
Mr. Mitchell, I'd rather see you have a chance of being successful in the community. You've been locked up long enough on this. I think you'd agree with that.
Yeah, but my parents and I have both been talking. I agree with them that I should just get the time over and get it done with.
Unfiltered, you're here as a representative from Community Corrections. I want to address you for a moment.
Yes, Your Honor.
Unfiltered, are you aware of any possible housing options for Mr. Mitchell if he's not able to have his own place or have a family member or friend assist him if he's released?
Yes, Your Honor. If he stays locally, there's second chance. If he goes to Sedgwick County, there's a ton more options over there for housing.
All right. Thank you. I appreciate your input. Mr. Mitchell, I want to give you the last word. Anything further?
No, I just rather go to prison and get the time over with.
All right. Very well. The court will proceed to sentencing in the case at this time. The court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, which the defendant has a criminal history score of G, thus placing him in grid box 5, drug G. The court hereby sentences the defendant to a term of 14 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court does find that based on this defendant having a very high risk score on the LSCMI, combined with a finding on the SASI that he has a high probability of a substance abuse disorder, this is a mandatory case for Senate Bill 123 treatment program. The defendant's ordered to complete an approved substance abuse program for up to 18 months as part of a community corrections probation for the same duration. Mr. Mitchell, I understand your request to the court. This is a mandatory, and the rule is what it says. It's a mandatory case for Senate Bill 123 at this juncture. This court has no legal option at this moment to place you in prison. You are presumptive probation on the grid. There's been no motion for a departure sentence before the court, and this is a mandatory Senate Bill 123 case. So your request, though I appreciate your candor, Mr. Mitchell, and I can appreciate your situation, the court is required to order you to be on community corrections probation for up to 18 months and to complete a Senate Bill 123 approved substance abuse program. Conditions of your probation at this juncture is reporting to an officer as directed, observing all laws. I'm going to require that you reside in a place approved by your community corrections officer. In other words, Mr. Mitchell, I don't want you on the streets. You shall not possess or consume alcohol or illegal drugs while on probation. At your supervising officer's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment suitably throughout your probationary term, even if it's part-time. Mr. Mitchell, you do need to be gainfully employed. You need to notify your supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. You shall have no contact with the co-defendant in this case. Mr. Sweeney, can you identify the co-defendant?
1 second, Your Honor.
Crystal Ivy.
I believe that's correct.
Very well. The defendant has a clear understanding of the person he's not to have contact with. He shall submit his DNA to the KBI databank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by his officer, follow all recommendations of his drug and alcohol evaluation, and complete all recommended Senate Bill 123 treatment and aftercare. He shall also complete a mental health assessment and follow the recommendations of that assessment, follow all standard conditions of probation, not have in his possession firearms or dangerous weapons, avoid disreputable characters and places. And let me comment on that, Mr. Mitchell. I think you already recognize that people that are going to continue to expose you to drugs are people you need to stay away from. And those places you also need to stay away from. That's what the court's addressing with avoiding disreputable characters and places. The court will also require the defendant to make monthly payments in a manner acceptable to the court. He is assessed a $400 KBI lab fee, felony docket fee, felony probation fee, community corrections fee, DNA database fee. All visit amounts are waived in this case, given the long-term incarceration that Mr. Mitchell has faced in the past, and $300 reimbursement to the Senate Bill 123 program. Mr. Mitchell, what kind of work have you done in the past and that you might be able to return to?
None. I have a horrible job history. I've went through 10 jobs in the last 7 years.
Okay. You ever done construction work or anything like that?
Nope.
Factory work of any kind?
Yeah. Hated it. Quit. Got in a fight.
Yeah. Well, I have no doubt, Mr. Mitchell, that you have the capabilities to be gainfully employed somewhere on some sort of not under the table employment, and the court will expect you to make your best efforts to pursue that.
Okay. I'm going to be transferred to Wichita because I have a warrant there
All right.
for possession.
I'm in no position to be able to establish a mandatory minimum payment at this point. I would ask the Community Corrections Department to try to work a plan with the defendant regarding some sort of payments every month, starting the first month after he's released from custody. On the issue of jail time credit, the defendant is awarded 105 days of time previously served on this case. Some point in the future, Mr. Mitchell, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain circumstances, a criminal defendant has a right to appeal a conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Mr. Mitchell, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. And you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Sweeney, are you aware of other sentencing-related matters that the court hasn't addressed yet?
No, Your Honor.
Mr. Watts, are you aware of anything?
Don't believe so, Your Honor.
All right. I have Christy Ashenfelter from Community Corrections on this meeting with us. Mr. Mitchell, when we conclude court proceedings, we're going to leave the meeting open briefly so that Ms. Ashenfelter can touch base with you And I want you to talk to her about perhaps some immediate housing options. Now, on this case, at this time, Mr. Mitchell, I'm releasing you from custody. You are on community corrections probation in this case as of right now. Now, you say you have a hold out of Sedgwick County?
Yeah, I have possession of a firearm.
Okay. You're probably going to have to go face that.
I was supposed to get sentenced on the 6th, and I wasn't, I was in here.
Okay. Well, apparently you're going to get transported over to Sedgwick County on that hold and deal with that. Now, I'm going to presuppose they're going to let you go at some point here soon, perhaps. And if so, then you're going to have some reporting requirements to the community corrections office. But I want you to try to coordinate what you can regarding maybe future housing or reporting with Ms. Ashenfelter before we leave that meeting totally today. Okay, Mr. Mitchell?
Okay.
Look, both the Kansas legislature and this court really want you to have a shot at being successful in the community. I hope that the Sedgwick County case nor any other life circumstance interferes with perhaps you entering a treatment program and completing this program so that you don't have to go to prison, Mr. Mitchell. Good luck in that regard. I hope you're able to make it. All right. Ms. Ashenfelter, again, if you stay on the meeting, we'll put you in a session with Mr. Mitchell so that you can visit with him briefly.
Yes, Your Honor.
All right. Thank
Your
you.
Honor,
Yes.
I just wanted to bring something to the court's attention regarding the Senate bill evaluation. I did not mark it or include that fee on here, and I wanted to explain that apparently the defendant had already completed an evaluation prior to being referred for Senate bill. So he technically did not complete the evaluation. And according to community corrections, the Sentencing Commission wanted us to use the evaluation that was completed and did indicate that he does have a Senate bill evaluation available to him later should he need it again. But I wanted you to be aware of that.
Okay. So this evaluation dated December 3, 2025 is available to be used in his other court case if necessary?
So that evaluation was for this case. However, should he need to be evaluated while he's on Senate bill and if he completes Senate bill and needs to go back into treatment at some point in the future, my point is I understand that he will have that available to him on this case because he was not referred for a Senate bill evaluation on this evaluation. So technically he hasn't completed a Senate bill evaluation is the short of the long. So I know the court did assess the fee to him. I just want you to be aware that technically this was not a Senate bill evaluation. He will go into Senate bill treatment. He is approved for that and does qualify. So that fee was noted on the PSI, just not the evaluation fee.
How did he get this evaluation done if it wasn't pursuant to a Senate Bill 123 referral?
The defendant may have to answer that to you. He spoke with SAC and that was facilitated prior to him being referred.
Yeah, what's included, Your Honor, is a SAC evaluation, and SAC goes out and does a number of evaluations out of the jail. I probably get a half dozen SAC evaluations from the jail a week. I didn't realize that the PSI writers could use that SAC evaluation as the Senate bill evaluation, or in lieu of the Senate bill evaluation. Is that what I'm hearing?
Your Honor, it's not that we choose to, it's what the Sentencing Commission apparently required community corrections to follow when he was referred for this evaluation for Senate bill.
All right. I noted in your statement of costs, Ms. Donovan, that you did not include an assessment fee.
That is
this court
correct.
just imposed one.
I did hear you say that, Judge, and that's why I just wanted to be clear on that it was not marked in the PSI and why. And I'll leave that to the court's discretion.
All right. So you believe it probably should not be assessed under the unique circumstances of this case?
He has not completed one. So I want
Then I'm going to rescind that order assessing the assessment fee, which was part of the 300 that the court announced earlier. The court will remove that $175 from his payment requirements. So the offender reimbursement part of 125 is assessed. The evaluation or assessment part is not assessed by the court. Thank you for that clarification, Ms. Donovan.
Your Honor, if I might jump in.
Yes.
For how Senate bill goes, he will still have to get a Senate bill evaluation.
All right. Then would the fee be assessed to him at that time?
Yes.
Yes.
All right.
What I mean is that it needs to be ordered by the court. I'm not sure where the confusion is besides SAC did an eval that is not Senate bill.
So you're telling me that I should go ahead and assess the 175 now for something that may happen in the future?
Your Honor, it will happen. It is a post Senate bill eval. We can do those. So he will have to do the eval to get into outpatient treatment.
Well, I don't want to cause extra work for community corrections, but this court is going to require community corrections to submit a modification to the court, and I'll assess the $175 after the evaluation is complete. All right, Mr. Watts, you seem troubled.
It's Judge, I gave up trying to think about it years ago. It's typical bureaucracy. You have to jump through the right hoops in the right order, the right assessment, because that's the way the rules are. Never mind that we have an assessment that Court Services believes is perfectly acceptable for purposes of the PSI. We're going to do one anyway because the rules say we have to, and we're going to charge the defendant for it because the rules say we have to. As I tell people all the time, it's government. It doesn't have to make sense.
Mr. Sweeney, do you have any corollary statement that you wish to make after Mr. Watts' pronouncement?
Nothing in response to that, Your Honor. I think we're good, and I have nothing further.
Well, everybody here is just trying to do their job in the manner in which they've been told to do it. So the court's given its direction on the matter. Mr. Mitchell, good luck. I hope you get out and have an opportunity to be successful in the community. There's nothing further at this time. We'll leave the meeting open for the conversation between Ms. Ashenfelter and Mr. Mitchell. Everyone else can leave the meeting at this time as the court is in recess.
Wesley, Mark Salomon, Wesley.
Right to the podium, man.
25T647066. Heather, tell Amy, Mr. Wesley's here, please. Good morning,
Okay,
sir.
John.
How are you? How you doing? You're charged with, state your name.
Mark Blessing.
You're charged with fraudulent false information, and you have the right to an attorney. Would you like an attorney?
Yes.
Okay. We'll set you up with a lawyer, and then either way, you're coming back in here, okay?
Can I ask a question?
Sure.
If I show that I have insurance and.
Well, you're gonna have to talk to the prosecutor. Your lawyer will, okay?
Just have a seat in the hallway, sir.
People against Mark Salomon, Wesley, 25T647066. John, come here, please.
Ready, John. Yeah, I got something.
Good morning.
Good morning, for the record, James Schlaf, 30720.
All right, how you doing, Mr. Schloff? Your name, sir?
Mark Wesley.
So, for purposes of arraignment, does he stand mute and waive formal reading?
He does, Your Honor.
All right. I'm entering a not guilty plea, and then he's going to plead to no proof of insurance.
Yeah.
John. Come here. To that charge, no proof of insurance, responsible or not responsible?
Responsible.
Can I ask a question?
Sure.
If I show return insurance, could that get?
Yeah, you get everything. Well, he's pled it to no proof from a misdemeanor. I can't. Okay, I'm gonna charge you 185 unless. Okay,
Just in furtherance, Your Honor, he has cleared up all the outstanding
good,
problems, including he has good insurance now. I presented that to you, Ross.
good. Your total, I'm gonna accept your plea, dismiss the misdemeanor, okay? 185 is your total. Can you pay that today or do you need time? When can you pay it?
Probably closer to the
You,
beginning of next month.
no problem.
2 weeks.
Yeah, I'll make it February the 7th. Is that enough time? Now listen. I need you to have a seat over there. We got an order from a probate judge that says that they're ordering us to take you into custody in the police department.
Hold on, I didn't finish.
It's over a mental health issue. I'm just telling you, I got an order from a probate judge and I have to do it. We're going to take you down there. Trenton's going to come and pick you up and they're going to take you there. Okay. Sir, I can't ignore a judge's order either. Okay. I just can't ignore the judge's order. I'm sorry. If you need more time on this, if you get to February 7th and you can't pay, call the court. We'll go on Zoom. I'll give you an extension. I'm sorry, but I have to have you taken into custody. I really am.
I'm gonna ask to take care of another case and then I'll go over and speak to him.
Sure. Thank you.
It's okay.
Yeah, I don't know anything about it. Kenneth James McKay Jr., 25B 149883. All right, Mr. McKay, your name? Officer McParlin needs to be brought in, Heather or John, whoever.
I don't have him on Zoom, Judge, so I'm not sure if he's here in person.
You wrote here, John.
He's on Zoom.
You see him?
No, I do not have him out here.
I got
Oh, you know what? You do, John. You don't have me as a co-host. That's why I don't see him.
Okay. This is again, officer, you can start your video. Kenneth James McKay Jr., 25B 149883. Your name, sir? Again?
Kenneth James McKay.
All right. Officer, your name?
Officer Gage McParland, Brownstown PD.
All right. Do you still wish to continue with your not responsible plea? You wish? Okay. I'm going to ask you both to raise your right hands. Officer, let me see your hand, please. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
All right. So you've both been sworn in. You can proceed, officer.
Yes, sir. On the day of the incident, which I don't have in front of me right now, unfortunately, I got a call to the area of Huron River Drive, just west of West Jefferson for an accident. When I arrived on scene, I seen two people pulled over to the side. One individual said that he was attempting to turn left to a private drive, and that Mr. McKay was impatient and went around him at the time he was turning, and unfortunately, the two collided.
So is is the alleged victim here traveling eastbound or westbound?
He was traveling westbound, sir. Both parties were traveling westbound.
Both were traveling westbound. So the defendant was going to, I'm sorry, the individual with whom Mr. McKay was involved in an accident with was going to turn left onto southbound Huron River Drive. Is that true?
He was going to turn southbound, but it was into a private drive, Your Honor.
I got it. I'm sorry. I misspoke, really. And then Mr. McKay was driving westbound as well. And there was a collision in what? The eastbound lane of Huron River Drive?
Affirm, sir.
I'm sorry?
Yes.
Do you have any questions for him, sir?
Yes, I just want to confirm that you recall driving eastbound and then making a 3 or 4 point turn to turn around to tell us both to proceed forward and then turn left onto the side street there.
Are you talking about after the accident?
Correct. Yeah, I agree. When he got there.
Yeah, I told them to turn down a side street over there. Correct.
So you can investigate the accident?
Yeah, and get him off the road right there.
Right. Okay. What other questions?
I have any other questions for him? Just the defense in the video that showed there was no.
Do you have a video?
I do.
Where's?
I don't have a video of the accident. I have a video of directly afterwards that shows his cruiser there and the other vehicle there to show that it was the day this happened. There was no debris on the road. There was no yaw marks. This was a very low speed collision. The other vehicle actually turned left and hit the side of my car. I was already alongside this person. This happened in a passing zone. He was stopped in the middle of the road with no turn signals on. I am a professional driver. I was in a Ford Focus that is very low to the ground. He was in a brand pickup truck. His taillights were in my face.
Wait a minute, slow down. So you're traveling west behind him. How far are you behind him? Initially, before you decided to pass?
Close. He was going slow. He was going dangerously slow for that area.
What do you mean dangerously slow for that area?
So if you're heading south on Jefferson, you go around on the Current River Drive, there's a turn road.
Right.
And people go around that road 45 miles an hour. And he was going maybe 5 or 10 miles an hour. And people come around that road. I was afraid of getting rear-ended. And then he proceeded to go slow. And
what do you mean you were afraid of being rear-ended by who? Was somebody behind you? Okay, but so you decided to pass.
Yes, in a passing zone, I decided to pass because there was no turn signals on this vehicle. I was under the impression that maybe he was irritated that I was there because he was going so slow. So I went to pass and I got alongside him and he turned into me. But the damage on my vehicle shows that he also turned in.
All right, slow down a second. Were there any injuries here, officer?
No.
And Your Honor, I do have something else to say whenever you guys are free.
No, I know, but I want to ask you that question first. Were there any injuries?
Oh, no injuries, Your Honor.
And was there serious property damage to the other vehicle?
No, sir.
And you don't want impeding traffic?
No.
Okay. All right, what do you want to add, officer?
On Huron River Drive, just west of where the accident did occur, I went back and I investigated that area. It's a permanent yellow line, which you're not allowed to pass. And I know the accidents happened there because the victim driver said, hey, it happened over there. And there's a solid double yellow line over there and you can't pass. So I said, okay, I'll go back and investigate. So I did go back and investigate that area. And the accident did happen there because there was very minor debris on the road. And there were clear yaw marks where the individual, Mr. McKay, clearly tried to go around where the victim said it happened. So there were tire marks in the lane. So he was not supposed to pass in that area, but he still did. And that was the area that
That's why you wrote him for improper lane use.
Yes, sir.
I disagree. I have video that shows no yaw marks and also.
If you want to show me any video, I have no issue with that. I'll be glad to look at it. I'm not sure that if it doesn't show me if it doesn't depict the accident.
Well, it shows where I was pulled over because you can see my tires because I went on the shoulder. The other vehicle did not go on the shoulder. I went to the shoulder after the accident.
I'll be happy to look at whatever you want.
Take me this small to I get into you.
You can hand me your phone. You can't see this though, can you, officer?
So
unfortunately not, Your Honor.
The problem is, man.
Can we get that up there? Would it be hard?
I don't know. This may have to be Shane. Don't call Shane.
Yeah. See if he can do that real quick.
You come in there, jumping down, script.
I have a suspicion that the marks that he was seeing were possibly where he arrived on the scene and turned around, because I can see all the marks in this video. And also where somebody backed out of the driveway.
I think what he was telling me is that the debris was in the zone that was a no passing zone. Is that not what you're telling me?
There was nothing missing from my vehicle. I don't know what could have been missing from his vehicle. His tire hit my car. There was nothing missing from my vehicle. Zero debris, zero wreckage. I have video of the vehicle as well.
Do you have vehicle of the area where the impact occurred?
Yes, I do. Where I believe it occurred due to the marks on the pavement. So what happened when he turned into me, there was a Dodge Ram pickup, like I said. He turned into me and his tire hit the right side of the car and it knocked the toe in on his vehicle. And you can see where he pulled away. You can see where the yaw marks are from the toe in his truck.
Was there any indication as to whether or not he had his turn signals on, officer?
Mr. McKay said that's what happened. When I asked the victim driver what happened, he says he did have his turn signal on and that Mr. McKay was impatient and went around him because he was going too slow. And then the reason for them pulling up, hold on a second, Mr. McKay. The reason for them pulling up is because where the accident occurred, according to the victim, there's also another lane that kind of comes diagonal from southbound West Jefferson. So they had to get out of that area. So they all pulled up more westbound on here on River Drive because you don't want to be kind of caught in that area, that intersection area where the victim driver said the accident occurred.
Which is precisely why I was trying to pass this person, because it's a dangerous area. And as the officer stated, the driver.
Hang on one second. Can you get that up on the screen?
Chance that he's gonna have to zoom in.
You're gonna have to zoom in on your phone and share your.
Yeah, I don't know how to do it. So I'm a very simple person.
Or you can show your phone.
Let me see it. Let me see it though. Let me see it.
I don't know. You're gonna have to play it again and again. I just explained to you the video. It shows where the double yellow ends.
Just hand it to me. Let me take a look.
Okay.
I can't see a thing from where you are.
It's very clear that there's no
Zoom in.
Yeah, and it's phone.
At the very end of the video, you can see the officer's cruiser pulling away towards me. And at the end of the video on the right, that shot is where my tire track is, where I pull away onto the.
What am I looking at now? I'm seeing a car.
I don't, because I can't see.
Well, I'm looking at a car. Is that from your vehicle, right? Well, what, this is after the accident, right?
That's correct. I had to document the area in order to.
I'm not sure why I'm looking at this. Why am I looking at this if it was after the accident?
Show you that number one, there's no debris. Number two, the tire tracks that are seen are from people backing out of their driveways, or when the officer arrives, his 3.4 turn he did.
Can you have this put up there? I want this officer.
I don't know how to do it, Judge. He's gonna have to zoom in with your Zoom
You
ID.
can Zoom with my Zoom ID and we'll get it on the docket here. Just be patient with me, officer, please. Okay, I'll be right with you.
No problem, Your Honor.
Okay, how we coming on Mr. McKay's Zoom?
I believe this is his phone out here, Judge, that says Kenny's phone. I'm pretty sure that's.
Well, then are we going to Zoom it on? Are we going to be able to put it on the
I
screen?
think he can phone share. He can share a screen off his phone from there.
Do you know how to do that?
If
He
he
has no
turns
clue.
his
Neither
video
do I.
on, if he turns his video on, there'll be an option if he taps his screen that says.
Try it. Turn your phone
share
on,
screen.
please. Mr. McKay, they should have, well, he's a St. Patrick's baby too, eh?
The officer should be here.
Big one coming up, Mr. McKay. I was going to say.
It is a big one coming up. I'm on the Zoom, my phone's there.
Okay, now what's he got to do? He's on Zoom. We see Kenny's phone on Zoom.
He has to have his video on.
You have to have your video. So start your video, bottom left-hand corner of your screen. Maybe Ms. McRipley can help. I'm just kidding. I want to talk to you if you get a minute. Thank you.
Sorry.
There you
And
are.
that there
I
should
see-
be, I think if you tap somewhere, there should be a screen share. Trying to think.
Yeah.
You not help? Sir, come on up here. My secretary. You got to be under 50 or at least to know all these technology rules, all these technology rules that drive us all crazy, right? Sadie, you're on YouTube now.
All right.
Okay. All right. Now.
I'll find the video.
Okay, Officer McParland, start your video again. Recalling Kenneth James McKay Jr., 25B149883. All right. I'm sorry. We tried.
Your Honor.
Yes, you're still under oath, by the way, officer.
Of course, Your Honor. I also have, I'm lucky enough to be off today. I do have a map in front of me so I can better explain to the court too and show you on Google Maps if it's okay with you in the court to show you how far this yellow line does go if that's okay with you.
Absolutely.
It's very clear on the video how far the yellow line does go. It's very clear where I was stopped on the shoulder.
Here.
Okay, just wait. Let me look at what he shows me first, okay?
Of course, Your Honor.
My concern here is, even if you were in a passing zone, I got testimony here that the guy had his turn signal on.
And me, a professional driver, I have driven 500,000.
What do you mean a professional? What do you mean a professional drive? You have a CDL?
With license ID and transportation company. I am testifying right now that the man's lights were in my face and there was not a turn signal on. I would not have, as a professional driver, I would not have passed this person had there been turn signals on. The officer stated himself that the person felt that I grew impatient and passed him. That proves that he knew I was back there. And I believe that the other person being denied this, that he did it intentionally. That he was going.
Got in an accident intentionally?
They didn't get my car intentionally. He was going dangerously slow. First of all, this was an elderly person. He was looking for a home that he must be unfamiliar with, because that's what he told the officer. That he was going to somebody's workshop there. Must be an address that he's unfamiliar with. That must be why he was going so slow. So I was behind him when it got to the point where I could get around him. I did. It aggravated that person that I was doing that. And
well, you don't think he intentionally slammed into the side of your vehicle, do you really?
I have a suspicion that that is part of what happened. The officer said himself that he thought that the other person thought that.
Okay, you're going to lose me on that.
Okay, well, that's fine.
All right, go ahead. Show me what you want to show me, officer.
Yes, Your Honor. I'm going to go ahead and just try to turn the video around. Do you know in the court in the app settings, if that's possible? If not, I'll do my best to go ahead and turn around so I can go ahead and explain it to you on the monitor I have in front of me.
You guys ask me technology questions and you expect me to know the answer, huh? You should know better.
My apologies, Your Honor. I'll do my best right here. Let me know if you can see my, Your Honor.
Yeah, I can see it.
All right, Your Honor. So this is West Jefferson.
And you can see it, right?
Yes.
Okay, go ahead.
All right. So as you can see, there's another lane, like Mr. McKay and I said, that it comes in through here. Okay, so if I just click like this and I go to the street view, here's that lane that comes through here, southbound. Now you see this double yellow?
Yes.
This is where, in this area, forgive me, that all the way up to this bridge that the victim driver said the accident happened in. And as Mr. McKay and I previously stated, they both had to get out of this area so that way they wouldn't get hit. You know, they can't just stay right here. So if you go this yellow line, as you can see, it goes down quite a ways. I'm zooming in, again, until we almost hit a street down here called Ludwig.
How much? Hang on, slow down. How long would you say? Now, it's hard for me to tell that double yellow line exists there on that roadway. Can you give me an estimate?
As far as yardage, Your Honor?
So you're saying it happened west of there?
It happened well west of there. The tire tracks on my video show exactly where it happened and exactly where my vehicle was stopped on the shoulder.
And
it was nowhere near that area. It was at
Where were they when you told them to move their vehicles? When you arrived on scene, where were they?
They were in this area between just past this. They were in this area right here to this area over here. I would say it's about a good probably 70 yards, Your Honor, 60, 70 yards.
From the end of the double yellow line?
Yeah. No. So from the line over here, which is the double yellow, the ending of it, to where I found them, which is over here.
Over where? Show me.
They pulled up. They were in this area. Okay.
All right.
And they said the individual said the accident happened like in this area right after where that southbound lane, like Mr. McKay and I said. And then I found there's a private drive. I don't know which private drive it was, but there were yaw marks that were like not 3-point yaw marks. They were yaw marks that go like this around, which clearly show, that someone was trying to go around, not someone pulling out and then going forward.
And you saw debris in that area? Is that where you saw the debris?
Yeah, there was minor debris, Your Honor. And my apologies, I didn't get down and look at like what kind of debris it was and trying to verify which, could have been from another vehicle, of course. But from where the victim vehicle said that this happened, I'm certain it was Mr. McKay's vehicle, and it was definitely within the double yellow, and it was clearly double yellow in the area that the accident, the victim said occurred.
All right. What do you want to say?
I want to say, I want to be able to show you frame by frame my video. I can prove to you where this accident happened.
Where are you going to show it? I got to have.
I have it on my phone, so I don't know. The officer should be here. That's what should happen. The officer should be here.
Well, we don't make them come here. And in fact, if you wanted to do an informal, I let them come here. Where are you now?
Where am I? I'm at my residence, Your Honor.
Yeah, which city?
Judge,
I'm in
what?
Shane said if he emails the video.
Go down and talk to John. You go down to the end and talk to the tech guy and see what we can do. Okay, let's do that. You go down and talk to the tech guy. Go all the way down the hall and they'll bring it up for you. All right.
Judge, we have Shane coming in with the video on Zoom.
Yeah, anytime he wants me to play it, it's what do you want me to give him to?
Whatever you want him to play it, he's ready.
You could give it to that. Okay. Recalling Kenneth James McKay Jr., 250-149-883. Officer McParlin, your name again?
Officer McParlin, Brownstown PD.
All right, start your video. Mr. McKay, your name again? All right, you're both still under oath. We're going to play the video, and you can tell me to stop it. Shane, will you stay there, please, and stop it but keep your voice up if you need me to stop it for any reason. And as the vehicle's traveling, feel free to tell me where you were, where the accident happened, any other important points you choose to bring up to the court. You can go ahead, I think, and start that now.
This is the day of the accident, the day it happened. We're going to do a video here. Here's the yield. Yielded for the person.
This was a different day, right?
This is the
officer
exact day. So the double yellow ends right.
There are no swerve marks there.
There's back out marks right there.
I saw where it ended.
So it's really hard without me being in control to show you things. At the very end of the video, you can see off the right shoulder, there's a wet tire mark on the pavement, and that's where I pulled off, where the officer had me pull off to go over. So that's how far down I went.
Officer, what kind of debris did you find on the scene?
I can't remember offhand, Your Honor. It was just minor debris. And like I said, I didn't get down and look at it and see if it was like, it was just minor. I can't really just describe it, Your Honor. If it pleases the court too, I have video footage as far as the body camera and stuff. Not with me. If we wanted to another day, I have it. It was clear day where this accident occurred at.
Play this video again, Shane.
This is the day of the accident, the day it happened.
You need him to stop. Tell him stop.
We're gonna do a video here. Here's the yield. Yielded for the person. Over here, the officer says he sees swerve marks. There are no swerve marks anywhere.
Stop, Shane.
There. So over there on looking at the screen to the left is where there are marks from somebody pulling out of the driveway and leaving. That may be the marks that he saw, but as you can see, there's clearly no debris anywhere at all. Because it was,
What time was the accident at?
I don't know the exact time.
What time was it, officer? What time did you respond? It says 2:38 p.m., right?
It was sometime in the early afternoon, Your Honor. I don't have that document in front of me today. It's one of the
What
only
time
days.
did you drive here?
Oh, you can see the officer.
I'm asking you what time you drove, you created this video.
It was just after the officer relieved me from the scene. At the end of this video, you can see the officer's cruiser pulling away and the other vehicle parked down the road. So if you pause the video right before the end, that's where you can see my tire marks pulling away from where the officer had me pull away.
You want him to keep going on the video?
Yes.
Keep going, Shane, please. Pause. Back up a little bit if you can, Shane.
If you go to the end and like 1 second from the end of the video.
1 second to the end of the video he wants, Shane.
There's the officer's cruiser.
Okay.
My pickup truck is in the distance. It's difficult to see there. It's on the left line.
That's the other vehicle involved?
That is correct. And if you go forward a little bit more and pause it, you can see my tire track. You can see the dot of the dash line, first of all.
Go ahead and go a little bit further, but give me about a second up there.
Right there on the right is my tire track from leaving the scene to go to where the officer had me parked. Correct.
You talk about the one that's traveling, that's
correct.
Right in front of the vehicle. Oh, you mean that one over there, you're saying?
Yes, correct. Where that's parked after the deed.
And then, Your Honor, if I may, in that video, I'm trying to zoom in on my, that's still double yellow right there. Am I correct?
It is not.
I don't think so.
No, that's fine. But I went back and investigated as far as the marks here. And I remember seeing that there were the yaw marks going around the vehicle during the double yellow. So I can't really see on his video very much, but I did go back because the victim was very adamant about me going back where he said the accident occurred at, and there was swerve around marks going eastbound.
You want me to see anything else?
But no.
You want to what?
He said the victim. He replied, he commented that the other party was a victim.
I can't hear him, Your Honor.
That the other party was a victim. I said, I would like to be a victim.
All right, Mr. McKay, I can tell that you feel strongly about this. Well, you're going to have to appeal then, because I'm sorry. I think that this happened in an improper, there was improper lane use, because I think that I think you did it in double yellow lines. I don't want to argue with you. I've given everybody every opportunity. He went back. He said he saw where the tire marks were. He saw some debris there. The victim pointed it out. I'm sorry. I find you responsible as charged. All you have to do, you drive what? You don't have a CDL, or do you?
Not
Well, you got a chauffeur's license, right? Officer, I'm going to give him his choice. If you have an objection, you tell me.
I'm always willing to drop it down, Your Honor, but you can go ahead.
If you want to plead to impeding, I'll take your plea. It'll be done. If you want to appeal, no problem. Then I'm going to keep this judgment in effect. You'll appeal it. You'll take it to the other judge. Maybe she'll agree with you. It's up to you. It depends if it's a wise guy question, but go ahead. Okay. I'm not going to revisit what my decision was. I want to give you a chance to appeal it. I can tell you feel strongly. Sometimes we think we're right and we're not. I'm doing what I think is right. I might be wrong. I've never said I'm right every time. I'll either let you plead to impeding, in which case you're forfeiting any right to appeal, or you can go down the hall, pay the $195, tell them you want to appeal. That will act as a bond, and you can go in front of the other judge.
Okay.
Okay. So you go down the hall. Heather, make sure that they set up an appeal on a formal $195. Good luck to you. You're welcome. Susan Lynn Wolf, 25G3067848 and B. Good morning, ma'am. Your name? All right, so they're going to use, they say you have a valid plate. They're going to go ahead and dismiss. They're going to dismiss the expired plate. They say you have a valid plate now, and you are going to plead responsible on file A to impeding with the understanding that they will then move to dismiss the speed. True?
I close it anything. I don't understand much of anything.
Okay, well,
Just know that I was having
let me slow down, man. Let me slow down. You have two charges. You have speeding and you have expired plate. They're offering you to plead to impeding traffic, which is no points, and it won't go on your record. If you plead to that, they're going to dismiss the speeding charge and the expired plate charge. Do you understand that?
No.
What part don't you understand? They're offering you to plead to impeding traffic.
Got close it entry. And I'm not understanding much of what you're saying.
Okay.
I just know that I didn't know that I had a medical crisis at the time.
Hang on. I want to make sure you understand before we go on. They're going to offer you the opportunity to plead to a 0-point violation. It's not going on your traffic record.
I have no money.
Ma'am, you can fight the ticket if you want. I can't solve that issue for you. I'm not going to, if you don't understand, I'll just set it for hearing on both charges and we'll have a hearing. I don't know what more I can do. They're telling you if you plead to impeding, it's 0 points. It won't go on your traffic record and the speeding charge will be dismissed. Do you want to plead to this first? Do you want to plead to impeding?
No.
What do you want to do?
I do.
Ma'am, you're not going to get argumentative with me now, are you? You're not going to get argumentative with me now, are you?
Don't know. I don't understand
What part don't you understand?
much of any of this.
Why, that's easy to say. I mean, I don't understand what's going on in the world now either. And I get that.
I was lost in.
Ma'am, you can set it for hearing if you want. I can tell this is going to be one of these where you don't want to plead and you want them to dismiss it and they're not willing to dismiss it. You're either going to have to plead to impeding or set them both for hearing. That's the best I can do. I will work with you on the payments. I don't intend to lock you up.
I don't have money.
Ma'am, I'm not talking about the money yet. I'm not talking
I
about.
gotta go to jail because I don't have the money.
So you understand what's going on. You just want to quarrel with me, right? You want to argue with me, right?
No, I just don't have money.
Ma'am, if you want me to set these for hearing, I will set them for hearing. If you want to plead to impeding traffic,
No.
you don't want to plead to impeding traffic. Well, why don't you sit down and think about it? I got all these people with,
Anybody help? Still gonna have a head injury.
ma'am, you want to argue with me, huh? I don't need to argue, and I'm not arguing with people. If somebody wants me to argue with them, they can pay me a lot more than the state's paying me. I'm not going to argue with you. Have a seat, have a seat, have a seat, and that's what I'm going to do. That's Susan.
Amy Powers.
Have a seat, and I'll be back with you. You think about what you want to do, okay? What's that?
Amy Powers, if you got it on your bunch.
Are you ready, Miss Wolf, or have you not figured out what you're going to do, and I'm not going to argue with you? You're either...
Bad head day.
So am I. Come on up here. Susan Lynn Wolf, 25G306-784 A and B. All right, your name again? So I'm going to ask you, you can either plead to impeding and they'll dismiss the speed and they'll dismiss the expired plate, or you can set them both for hearing.
Okay, but I gotta go to jail because I have no money.
I will give you time to pay.
I'm in the hole every month.
Ma'am, I don't know what to tell you. I can figure something out, but I'm not waiving your fines. I waive your fines. I got to waive everybody else's fines.
That's why I want to go to jail.
I don't want to send you to jail. Do you want to take this deal or do you?
Because of the judge, okay?
You what?
The trial I was told I would lose because everybody knew that auto owners own Terrence. The judge said I wasn't injured in the accident. I'm living on less than $10,000 a year because of that damn judge.
Stop it. Judge Terrence was a very, very, very well-respected judge.
He said
so wait a minute. I'm not talking to you about Judge Terrence. I believe he's deceased. I had respect for him when I was a lawyer, and he was a very well-respected judge, and that's not fair. And I have nothing to do with that.
Right.
All right, so you're going to...
I have no money.
Ma'am, I can't...
I need to go to jail because I have no money.
All right, do you want me to set it for hearing, or are you going to plead to impeding?
I have no money. How do I...
Have a seat. You think about it further, but you're not going to bring up you're not going to start disparaging a judge, particularly one who's deceased. Yeah. Have a seat. Have a seat. Have a seat. Have a seat.
Sit down.
Don't tell me that damn judge was a good judge.
Ma'am, you come up here 1 second. You want to go to jail? You keep acting like this, but it's not going to take care of your ticket. You are not going to carry on in a courthouse like this. Come here. Come up here.
I'm extremely dizzy at the moment.
Sit down, man. You're not going to disparage a judge. And you're not going to disparage somebody who's deceased. And Judge Terrence was in. Well, I got to tell you, my money would be on Judge Terrence's decision because he was a very, very, very good man and a very respectful man. And I'm not talking about it, and you're not mentioning his name again. And when you tell me you're ready, I will call your case. All you have to do is raise your hand. I will call your case, and I will either set it for hearing or I will take the plea.
I gotta go. I gotta go. I can't be here. I gotta go. I gotta go.
Set it for hearing, Heather. Go down the hall and get your notice, ma'am.
Okay, Judge. You just want me to set it for, you want me to set it for a formal?
There are days that I wonder. There are just days that I wonder.
Don't you want me to set that for a formal hearing?
Everybody, so many people are so angry now. Wow. Thanks a lot, Lieutenant. Is Trenton out there yet?
What's that? Yes, they are, Judge.
Get him in here.
I'll bring him in right now.
Teresa Lynn Riddle, 25T642922. Thanks. Ms. Riddle, if you're there, okay.
Come here, Ms. Riddle. Come on. We're going back in front of the judge. You can get. We're not. Miss Riddle. Miss Riddle. Come on. We're going to deal with this other matter first. Your car can't even wait. Come on. We got to go see the judge. Come on.
My Richie Lion spilled water on my phone.
That's not a priority right now. Come on. Come on. Come on. We're going in front of the judge again. Come with me. Come on.
Richie Lion spilled water.
Ms. Riddle. Ms. Riddle. Ms. Riddle.
You hear the judge talking to you right now?
Ms. Riddle.
On that red face.
Ms. Riddle. Get in front of the camera, stop yelling and carrying on, and behave yourself. Your
Richie
name.
Lyons brought my car out front and spilled water on my phone.
I don't want to hear it.
Last night.
I don't want to hear it. Tell me your name. What's your name?
Teresa Riddle.
Your appearance.
He's my witness that he spilled water on my phone last night.
Ma'am,
My
Ma'am.
phone was
ma'am,
Oh,
I'm
so-
gonna, you know what I'm gonna do if you'd say another word? I'm gonna have them hold you overnight with no bond, and then we'll try tomorrow. And if you give me this guff again tomorrow, I'll just put you back in until the following Wednesday and we'll try again. So don't be carrying on with me. I'm in the middle of an exam. I'm gonna arraign you, but you're not gonna carry on like this. Do we understand one another? Yes or no?
Yes.
All right.
Yes.
Now we're going to talk about the arraignment. Does she stand mute, wait, phone rating?
Yes, sir.
Why wasn't she here?
Your Honor, my understanding is that some water spilled on her phone, and my interpretation was that prevented her from being able to call an Uber or whatnot to get here. But that is my best interpretation for my conversations. Very.
Richie Lyons picked me up.
It wasn't your
I'm
turn
sorry.
to talk.
I'm
It was not your turn to talk.
I'm sorry.
Her phone got wet and it ruined her phone, and so she couldn't call. Is that,
Yes.
I'm just asking, is that true?
Correct.
Couldn't call, and she was unable to get a ride. She didn't have.
She lives on Charlton. You still live on Charlton, ma'am?
No, I live at the Southland Motel
My
right now
client is
temporarily.
She's unhoused. She's staying with a friend who happens to have a room at the Southland Hotel right now. She got a P.O. box. She can give a quote. Yeah.
Sergeant, how did you pick her up today? How did they pick her up?
Good afternoon, Judge. Detective Sergeant Mark Driscoll. After I was made aware that a warrant was going to be issued, I was able to realize Miss Riddle was in town on our flock camera system. One of our officers located her over at Walgreens, made contact with her. They were made aware of the warrant, that she didn't appear this morning as she was scheduled to, and that's where we're back at it again today.
And she was at Walmart? Wait a minute.
Walgreens. Walgreens, Judge.
Walgreens in
in our
Trenton?
city. Yes, sir. Can I add one thing to the phone idea
Sure.
real quick? And I know you're in the middle of the exam. So we have 8 from about 2 a.m. yesterday, last night, early this morning to 7 a.m. that Miss Riddle emailed council people and the mayor of Trenton to articulate an old case that she believes that we haven't investigated properly, make allegations that have been unfounded. And I'm not going to go too deep in the weeds because it doesn't necessarily pertain to this, but there's this repetitive behavior of her mass emailing and people that if she wanted to report a crime, she would, Miss Riddle, I'm not talking.
Ms. Riddle, Ms. Riddle, Ms. Riddle.
The judge is talking to you, ma'am. Don't talk to me. Talk to the judge.
Ms. Riddle, look at me, ma'am, or I'm gonna cut this off and we'll bring you tomorrow.
So my point, Judge, is I believe that her phone was operational. She was able to send 8 consecutive emails between 2 a.m. and 7 a.m. to the mayor of Trenton, to several city council members. So to me, the excuse that her phone wasn't working, obviously working well enough, ma'am, I'm not talking to you again.
Stop it.
So that's just what I wanted to articulate, that we have this ongoing issue with her within the city, contacted people that she wouldn't report a crime to. Now her claim is that her phone was broken, Judge. That's where I'm at.
It was
Prepare forfeiture, ma'am.
By Richie Lyons, and I need to hear.
Ma'am, I'm gonna really lose my patience here if I already have it. I'm not gonna ask you again. You don't want to show up on this case. You weren't here March 26th. You weren't here April 24th. You weren't here December 4th. I arraigned you yesterday and you didn't show up today. We're not putting the warrant in the lien, but I am forfeiting the bond. And the new bond's going to be $10,000, 10%. And if you post that and you don't show up, you know what I'm going to do next time? I will set 100,000 cash and you will be sitting in jail until I get ready to take care of this case. This is ridiculous. You don't get to do this. Ma'am?
I have evidence.
I'm not going to argue with you. And that's it. We'll give you an early court date. Unfortunately, you just screwed yourself by not showing up today because Trenton isn't going to be back in front of me for 2 weeks. So I hope you can post $1,000. What, ma'am?
I need
Ma'am?
Richie Lyons here.
I've
He
had
was the
it.
one
Ma'am?
who spilled the water on my phone when he picked me up last night.
Ma'am?
Do you believe Richie Lyons?
Ma'am, I believe that you were
He's my only witness.
I believe if you were at Walgreens in Trenton, that you could have made it here for your court date. Period.
No, my phone
Ma'am,
died.
ma'am,
Read
ma'am.
the receipt. The receipt says
Ma'am,
the phone was dead.
This hearing
when I
is
went to
over.
Taylor.
You don't understand. Same bond conditions as I outlined yesterday. Now you have to post 1,000. If you want to forfeit that, that's up to you. You must have a lot of money because you forfeited a
I'm
ton of
on
bonds
Social
on this.
Security disability, and I only
Ma'am.
get a pension from
Ma'am.
Customs and Immigration
Keep your mouth
for
down.
10 years. I
Ma'am,
served.
keep your mouth down. What, Sergeant?
Sorry to bother you, Judge. I know you got a hearing. Can we put in a stipulation for her not to contact? Because I don't want this to get to another harassment complaint. If she has complaints, criminal complaints, she's obviously welcome to come to the Trent Police. The contact with the mayor on complaints.
Well, I don't know. I can't. Hang on. I can't, ma'am. Will you please stop looking at him? Rolling. I can't believe you roll your eyes and you're this disrespect. I just can't. Ms. Merito.
I've been friends with Deb Devitt, with the
I
mayor.
don't care who your friends are. I don't really care. I'm friends with Deb Devitt, but I could care less.
With Deb and all of those guys.
10%. I can't order that, detective. I mean, I can't order not that they're not witnesses to this crime, so I can't really order that. But you can't violate a law. So if you keep harassing them, they're going to charge you, and I'm going to forfeit your bond again.
I've only contacted them one time, Judge.
I don't want to hear it. I don't want to hear it. I don't want to hear it. No. What are we doing? The 29th. That's the best I can do for you. I hope you can post. January 29th will be your court date. At some point, you're going to learn to show up. January 29th at 9:45. Good luck to you, ma'am. I wish you well. Have a great day. Thank you very much.
Thank you.
All right, thank you.
Yeah, I think the judge basically just said, I don't care who your friends are. I don't care what your excuse might be. You can't post your bond. Enjoy the next 2 weeks in jail. And ladies and gentlemen, I'm saying thank you very much for hanging out with me tonight and watching these court cases that I've put together from today's variety of dockets available all over the web. I am your humble lone wolf Usul. I am your host for these here compilations that we do nightly. I am your curator for this here Court Gallery channel. And I'm your humble servant. And I want to say thank you and good night. I am out. The real question is, what do I have prepared for tonight's obligatory Ferris Bueller day off post stream after credits scene? Nothing. Absolutely nothing. Have a great night, Courtroom Files. Great seeing you again. Come on by next time. Thank you very much, Sue Boxford, for your sticker again. And all of you are wonderful. That's all I got. Stay crispy. You know. Station.